conversation on that right now. You're referring to 18 U.S.C. Section 31?
Yep.
Okay, so that
Definition 6.
Sub 6 specifically says that the term motor vehicle, and that's for purposes of that statute. And that chapter, the chapter covers certain specific crimes, specifically destruction of aircraft or aircraft facilities, destruction of motor vehicles or motor vehicle facilities. Talks about Section 34 is penalty when death occurs. Section 35 is imparting or conveying false information. 36 is drive-by shooting. 37 is violence at international airports. 38 is fraud involving aircraft or space vehicle parts in interstate or foreign commerce. 39A is aiming a laser pointer at an aircraft, and 40 is commercial motor vehicles required to stop for inspection. So none of those crimes have been alleged against you today.
Right, but I wasn't operating under commercial purposes.
Right, but you haven't been charged with a crime under that chapter. Therefore, the definition of motor vehicle for purposes of that chapter is inapplicable today.
How so?
Because that definition in the statute, it specifically says, for purposes of this chapter, the following definitions apply. And that's when it defines what a motor vehicle is, for purposes of that chapter. And that's very common in statutes where it says, for this chapter we mean this. Now that doesn't mean for another chapter, motor vehicle may be defined differently. So Oregon law has defined a motor vehicle that covers your Mitsubishi.
But I still have the right to travel.
Oh, you certainly have a right to travel in a motor vehicle, provided that if you're operating on...
It's a basic right, and there's plenty of court cases, Supreme Court cases that prove that.
Well, and on the issue of whether or not 18 U.S.C. Section 31 sub 6 applies, I'm going to rule against you on that one, because I've reviewed that statute.
Whether or not it applies or not, I still have the right to travel in my private conveyance.
Well, and that is not within my purview at this time. That what's before me today is two violations, which is one is failure to carry proof of insurance, and the other one is improper display of tags, or essentially license. So whether or not, I can't give you an advisory ruling as to if you were cited for driving and we got into an issue of whether or not you did have a right to drive your vehicle on roads. That's not before me today, and I can't give you an advisory ruling on that. So I'm not going to address that. That's something that, if it comes up again, it comes up again, and we'll address it at that time. But I'm kind of limited to the two violations have been asserted against you at this point. So I'm from a legal standpoint, I'm telling you that I find that Section 18 U.S.C. Section 30, or pardon me, 18 U.S.C. Section 31 sub 6, the definition of motor vehicle in that statute, which is part of the definition section, is not applicable today. Okay, and that's obviously you can appeal that, and I'd encourage you to do so. Okay, but for purposes of today, I'm determining that does not apply. So if you have any factual questions for the officer, you can certainly ask them. And I'd love to, actually I want to hear specifically, and as I said, we're going to get into the constitutional issues and the other issues, but what I really would like to get down to is resolving the factual issue first, which is specifically, did you have insurance, and did you have the license plate properly displayed? So I would request, I can't require you, but I'm going to request that you address those issues first, and then we can go through the laundry list of other issues.
But there's no jurisdiction anyways, because where's the contract and where's the injured party?
Okay. And there, I assume you're referring to...
You're saying that it's a civil action, so there's two things. Where's the contract that's involved, and also the injured party?
It's not a civil action. This is a violation, which is a non-criminal matter.
You told me at the arraignment that it was a civil action.
Okay, and that is the way I use civil action is to differentiate from criminal actions. In essence, in actuality, there are criminal violations, there are non-criminal violations, and then there's civil actions. This is really a non-criminal violation, and if I said civil, I misspoke, and I apologize for that.
Okay, but where's the court's proof of jurisdiction?
He has established jurisdiction because you were within the city limits of the city.
But I wasn't driving, I was only traveling.
Oregon law references operation of a vehicle, And my understanding, according to the officer, you were operating the vehicle.
Operation, I think I have the legal definition in here of what the operation means. Because lawfully I was not operating. Don't seem to have it in here.
Officer, you don't sound well.
No, I'm not. I'd better.
I don't have the definition in here, but if the court will look at Black's Law Dictionary, it would explain the definition of an operation.
Okay, and what do you believe the definition of operation is?
Okay, so you have a driver and an operator. The driver is the one who is employed to conduct the coach or carriage in the act of commerce, and the operator is one who actually owns it, to my understanding.
Okay, and I will disagree with that. My analysis, my experience in almost 30 years of practicing law, is when you're dealing with private, and we're not talking about commercial vehicles here, we're talking about private vehicles. The operator is deemed the person who is physically operating the car. It doesn't need to be an owner. They don't need to own it if they're operating it. And I've had situations where a fairly common one that the Court of Appeals has addressed at least once or twice is where someone has passed out behind the wheel. So they're parked off the side. I had this happen in one case, not with a client of mine, but an adverse party. The person had come back from a Christmas party, had been drunk, passed out, but the car was still running. The keys were in it, the car was running, the lights were on. He had passed out though, and under Oregon law, he was deemed to be still operating that since he was behind the wheel with the car on. So under Oregon, current Oregon law, operating is determined to be behind the wheel, actually physically using the car.
Looks like I'm going to have to appeal that one too.
Okay. And trust me, I seriously do encourage you not, I'm not trying to be snide, I'm not trying to be sarcastic. Again, I admire someone who's challenging the status quo, so I want you to challenge this. If I'm wrong, I want to know I'm wrong. Okay? So, certainly appealing that would, I encourage you to do so. So, do you have anything? One of the reasons I want to have you get back to the factual questions with the officer is because he is ill and I don't want to make him stand up any longer than he has to. We can certainly have continued legal discussions, but I'd like to allow him to at least rest without having to worry about answering questions any longer than he has to. So, do you have any factual questions for the officer?
Well, one thing that did arise was because I was following you and I told you that I had the right to observe officers in their duty, but you told me that you didn't consent and that you would write me a citation for that. Do you have the legal...
I did not make that statement.
I have it on recording.
Okay, why don't you play back the recording?
I can do that.
But let me ask, before we do that, what's the relevance of that?
Because that's the original reason why he stopped me.
Okay.
Because I was...
I have testified that I stopped the Mitsubishi there because it did not have a front plate display. That's the reason for the stop.
But you also said another thing that concerns me is the fact that you're following me. Why are you following me? I have it all on tape. I can play it back.
Gentlemen, it's and here's where I am on that. Whether or not the officer stopped you, had an ulterior motive for stopping you, is somewhat irrelevant here. That may be a basis for a tort claim notice. If you feel he was harassing you, if you feel he was retaliating against you, that is more of a civil claim. That doesn't address, that's not a basis. If he had a reasonable basis for stopping you, which according to his testimony was the failure to properly display the license in front, that's what's relevant. Whether or not he did it for, putting it one way, if he did the right thing for the wrong reason, there may be other avenues for you to pursue, but that's not going to be relevant for today's case. Okay?
All right. And then the other thing too, I had another question. I can't think of it now.
And we can certainly, if you want to address some of the legal issues, As long as the officers, as long as you're able to make it.
Yeah, I'm fine.
Okay. If you and I want to address some of the constitutional or the other larger issues, we can do that and allow and if you remember your factual question, I'll let you ask the officer later on. Okay? What other legal issues would you like to talk about?
Well, I have a couple of Supreme Court cases here that state the right to travel. The use of the highway for the purpose of travel and transportation is not a mere privilege, but a common fundamental right of which the public and individuals cannot rightfully be deprived. Chicago Motor Coach versus Chicago.
And what's the year in that?
It was 1920 something, like 23 or 30.
Is that it's a U.S. Supreme Court case?
Yeah, I have the site right here. It's 169 NE 221.
Okay. 169 NE.
Yes.
What's the page number?
221.
Okay. I will tell you just based on that site, it's unlikely to be a Supreme Court case. That more likely came from the Northeast, one of the Northeast districts, or it's probably a state case from somewhere in the Northeast. U.S. Supreme Court cases usually have sites of either U.S. or S Court, or I'm trying to remember what the other
Supreme
one
Court reports.
Yeah, well, SCT is Supreme Court reports, but NE is not indicative of a U.S. Supreme Court case.
Okay, yeah, to my understanding that was. Okay. See, I got this other one here. This one's Thompson v. Smith. It's 154 SE 579. The right of the citizen to travel upon the public highways and to transport his property thereon, either by carriage or by automobile, is not a mere privilege which a city may prohibit or permit at will, but a common law right which he has under the right to life, liberty, and the pursuit of happiness.
Okay, and once again, the SE, generally when you see a reference to SE or NE, they're referring to reporters that are published by the West Publishing Company. And what they do is they separate the country into various regions. They have Northeast, Southeast, Northwest is one of the big ones. They got one just for California. I don't recall, they have one for Southern, which is SO. So those, to the extent that those are from Southeast, those two cases from Southeast and Northeast, they are not binding upon Oregon courts.
Okay, Shapiro versus Thompson. This is 394 U.S. 618. The right to travel is a right so basic it doesn't need to be mentioned.
Okay.
And then there's Murdoch versus Pennsylvania, 319 U.S. 50 or 105. I'm sorry. A state may not impose a charge for the enjoyment of a right granted by the federal Constitution.
Okay.
Shuttlesworth versus Birmingham, Alabama, 373 U.S. 262. If the state converts a right into a privilege, the citizen can ignore the license and fee and engage in the right with impunity.
Okay.
Marbury versus Madison. I don't have the citation on
Oh, I've
this
got the
one.
Marbury. That's one of the old ones. I learned that back in law school.
Anything in conflict with the Constitution is repugnant and null and void of law.
Well, yeah. I mean, Marbury dealt with a number of different matters.
Right.
That was
It
certainly
was a
one of them.
judicial issue, but that was one of the things brought up by John Marshall.
Mhm.
And let's see. Kent v. Doles, 357 U.S. 116, 125. The right to travel is part of the liberty of which a citizen cannot be rightfully deprived without due process of law under the Fifth Amendment. Shackman v. Doles, 96 APP DC 287, 225 F2D 938 at 341 or 941. The right to travel is a well-established common right that does not owe its existence to the federal government. It
In
is
that case,
recognized.
is of the federal second district, which would not. We're in the 9th district, so that may have. It has no binding effect upon Oregon courts. And those
Right,
ones,
but-
they're federal courts. Do you have any Oregon law?
I don't have any specific Oregon law, but the Kent v. Doles is a Supreme Court case, and so is Shapiro v. Thompson.
And I understand that, but there's also a difference, and the courts have looked at this as far as what the state's rights are versus the federal rights, and federal highways versus state highways.